I just want to introduce to you, for those who aren't familiar, the IFDA. We are a nonprofit organization that supports to the trade, education, and career advancement. Right now, to become a member, if you want to get involved in the trade and you want to be more active in the industry, this is a great time to test the waters. It's a great opportunity to network within the community and to talk with people like Seth. Love to thank our sponsors: International Gold sponsors, The Shade Store; International Silver sponsors, Hunter Douglas; and New York Chapter Gold sponsors, Benjamin Moore, Seegerman, Kravitz, Stacy Garcia, 200 Lexington; and our silver sponsors, American Hardwood, Fisher and Paykel, 41 Madison, Hoffley America, and New York Now. Seth Kaplowitz, he'll be sharing his insights and expertise with us on how to enhance and up-level our businesses. Welcome, Seth.
Thanks, Garrett. Thanks for having me, and thanks to the IFDA for having me. I'm happy to be here today, and personally, I'm happy that we're on the backside of this storm, and hopefully that everybody who's on the call doesn't have any damage. So glad to be here today.
Great. Well, we have quite a bit to go through. Let me just open up. Here we go. I wanted to hear a little bit about your business. You are actually a very creative aware lawyer, which is awesome for our industry because it is difficult to find a lawyer who understands our creative process and how we work. Can you tell us a little bit about your practice, the types of clients you typically work with, and issues you deal with?
Yeah, sure. So I guess I'll give you the short version because the long version is long and somewhat pedestrian. So I've been practicing law for about 20 years now, and I started off traditionally at a large law firm, and then after that I went to a boutique law firm. After being there for a while, I actually went overseas for about 8 years, where I ran the legal operations for a private equity firm. So as a result of doing that, or while I was doing that, I had exposure to a lot of deals, a lot of cross-border transactions, a lot of interesting things, and I saw a lot of interesting sites. When I came back to the States in 2012, I decided that rather than go to a firm and rather than stay in private equity, I thought it was a good time to start my own firm, which we did in 2012. So we do this for a while. The firm itself is a full service firm. We have clients from a variety of different sectors doing a lot of different things, and myself and the other attorneys in the firm do a lot of different things for them, from fundraising to contractual matters to litigation, arbitration, a lot of different types of things. For me personally, I decided that I was going to narrow my focus because I was more interested in working with people who had kind of a perspective on things and goals that were similar to mine. And what that ultimately led to is that I decided I was going to work almost exclusively with lifestyle brands and creatives and design professionals. And I thought it was a good fit for me because, first of all, I have an interest in the subject matter itself, so that always helps. But also, I like working with creative people. That's not to say, in case any of my other clients are on this, that I don't like working with, with people who are a bit more, let's say, linear or, a bit more spreadsheet focused. But, what I found over the course of my career is that working with people who, use their minds in order to come up with different things that make our lives better are the people that I'm most interested in working with. So that's kind of where I am in terms of my clientele. I work with people kind of across the creative industries. I work with designers, I work with interior designers, I work with a variety of other just kind of creative types. I work with companies that are in the home decor space. I work with companies that are just kind of generally in the lifestyle space. I have clients that make apparel. I have clients that are in the performing arts. So that's kind of an overview of me and who I work with. I try to limit my practice to working with people that I feel like I can help empower to take their business to where they want to go. And I view it as an iterative process. It's not just me telling you what to do, and it's not necessarily just you telling me what what you think that I should be getting done for you, but rather us sitting down and trying to chart out where it is that you want to go and how we're going to get you there, both legally and operationally to a certain extent.
I love that. And that's fantastic, because it is difficult as a designer, and because we're so passionate in our field about what we do, and we're very focused on that iterative process of creating a better world, a better environment for our clients. It can be difficult to take the perspective of business and really lay out how we want to run that business and make sure it's profitable, because we do want to give so much. So I'm really excited to be asking you some more questions about contracting and things like that to set that up and really be able to negotiate the space so that we can be most creative and still be profitable within our businesses. First, I wanted to talk a little bit more about your clients. I know you worked with Flavor Paper, which is a really interesting brand. They've created some really interesting and creative wallpapers. And to get to without talking too much in areas you can't, but how have you been able to help them scale their business and help them negotiate contracts, being that they are creative and they are kind of compiling imagery from perhaps images they don't own, to create this new and exciting product that's really new to the market?
So yeah, I've been working with Flavor Paper for a while now. I think it's 5 or 6 years, and I don't know if John's on this or not. If he is, hi John. The great thing about working with Flavor Paper is that you get to work with John Sherman, and John is, I put in the category of super creative and super motivated. So it's really been fun working with John. And, you know, from a legal perspective, sometimes it's a little challenging to try to keep up with the various things that they're doing. And, you know, because a lot of them are, you know, beyond the kind of ordinary two-sided licensing deal. You know, there's a lot of different images. There's a lot of different things coming into play. So, you know, I would say that, you know, as far as Flavor Paper is concerned, or any of my clients are concerned, the first thing that I do in order to help them further their business objectives is to sit down and listen to them and try to get an understanding of exactly what it is that they're trying to accomplish. It's, you know, it's kind of self-evident to know that if I'm working for a wallpaper maker, that they're going to be interested in licensing designs to use in their paper, or, you know, licensing their products for sale in various different places. And I think it's also important to understand that licensing is a two-way street. You can license things to use in something that you want to make, or you can license what you're making for somebody else to sell. So step number one is always get an understanding of where the client wants to go. You know, step number two is then trying to implement that in a methodical fashion while negotiating the best deal for the client, and trying to give the client as much optionality as possible. And that's kind of one of the things that I really focus on. I want to create options for my clients at all points in time, right? It's great if you can enter into a deal. Let's use Flavor Paper as an example. It's great to enter into a licensing agreement, but if you enter into a licensing agreement and you give away more than you wanted to give away in terms of territoriality, like, you know, where the products can be sold, or in terms of streams of commerce, like, you know, through what mechanic, can it just be sold online? Can it be sold in museum stores? You know, you can find yourself in a position where you may have something successful, but you're locked in for a term of, you know, 5 years, 7 years, 10 years to a deal that doesn't necessarily suit you anymore, and you're precluded from being able to sell and promote your products in other avenues. So we try to look at carefully tailored agreements, and we try to make sure that we're getting as much as we can get, you know, while giving away an appropriate amount. The other thing, and using, you know, continuing to use John and Flavor Paper as an example, is, you know, what's been interesting about working with John is that there also are a variety of kind of non-traditional deals that we do. So, you know, when people do a licensing arrangement, typically it's a two-party arrangement. Somebody wants to do this, the other person is happy to have them do it, and we enter into an agreement. With Flavor Paper, we've done some other interesting deals. We did, you know, basically a 4-way deal with Flavor Paper and Michael Reynolds and Eric Hoffman and the Tom of Finland Foundation, which was a bit atypical in that there were 4 parties to the licensing agreement, and each party was contributing a bit. And we didn't have an off-the-shelf agreement for that. So it was a lot of sitting down and understanding not just what John wanted and what he wanted to accomplish with this, but also understanding what Michael wanted to get and listening to him and Eric's studio and and then obviously a lot of input from the Tom of Finland Foundation. So it's things like that. I think the most important thing is to be able to listen to your client and understand what it is that they want to get, where they're trying to go, and then get them there. There was a quote from JP Morgan from, back in the day when JP Morgan was issuing quotes, and I mean the person, not the bank, but he said, I don't pay lawyers to tell me what I can't do. I pay lawyers to figure out a way to get done what I want to get done. And that's kind of the philosophy that we operate off of is, what do you want to do? Let's figure out a way to get that done.
That's fantastic. And I really love that because it is often that I feel like lawyers tend to streamline their services to the point where they automate you. And as creatives, we don't like to be automated, and we have a more mindful way of operating business. So tell us a little bit about how you sit down with your clients and work with contracts. We'll get back to licensing because that's all very interesting. But let's start with contracts, because I really think that framework can really be the foundation of every designer here. If they can establish the parameters of what their business goals are within that contract, what the payment and when the payment is due, would alleviate a lot of pain points that I've heard over time with designers. Grievances about clients not paying them, or clients believing certain services should be added on, or that they can ask for certain things after the fact. And people run around kind of like chickens with their heads cut off trying to make it work, when some of these things could be really solved and resolved within the contract, and having that all laid out at the beginning so that everybody knows how to proceed, and we're happy and we're guarding our time, we're saving our energy, and we're making the money that we intended to make on each project. Tell us a little bit about how you negotiate contracts or set up contracts specifically for your designer's goals.
Sure. So what I would say is that first I kind of approach it like I approach most things from a humanistic perspective rather than a legal perspective. And that's to have an understanding and to ensure that my clients have an understanding that at the end of the day, we can structure whatever kind of contract we need to structure. While you correctly point out that you can get a variety of different templates, and there's a lot of, kind of standardized contractual provisions that people may use. The bottom line is that a contract, even the best contract on the face of the earth, is only as good as the people on either side of the contract. So we can draft a spectacular contract, but if the party on the other side of the contract isn't going to do the right thing, your options are going to be what they're going to be. And as I tell most clients, if you've gotten to the point where you have to litigate over something, everybody's already lost. So that being kind of the starting point, and the way that I view designers and the services that they're offering are very similar to the services that I'm offering, right? We're both in the professional services business. And one of the things that you don't want to have to do is you don't want to have to interrupt the services that you're giving, or you don't want to have to stop, dealing with a client, or, trying to do business with a client to get engaged in a protracted or an unnecessary contractual discussion. So there's a couple different aspects to that from my perspective. And the first is that everybody should have a contract that's ready to go. When, a client wants to hire you, for you to have to stop everything and then do a contract from scratch, or, change a lot of things in a contract, is not an effective use of your time. And, what we always want to be doing is making sure that the people that we're working with are focused on doing their job, not doing the legal job, not doing the accounting job, not doing the other jobs. We want people chose the avocations that they chose for a reason, and we want to try to empower them to focus on their business and not focus on a lot of collateral issues. So in terms of the contract, what we strive to create is a replicable contract for our clients. And what does that mean? That means that you have a contract, just like we at the firm have an engagement letter. And when it comes to that point in the relationship that it's time to send out a contract, you can just literally hit send. You have your contract, it's ready to go, and you push it out to the client. What we say, and one of the things we've been talking about is that we view contracts as an extension of your brand, right? So you're a designer, right? You make things look better, and when you're talking to a client, when you're giving your client, some feedback or giving them a proposal, when you get to the point where there's a contract, it's really the first opportunity that the client has to look into, like, your operation. So they know they like your design, they like your ethos, they like, other projects. They have made a decision at this point that they like you and they want to work with you, but they don't know, how professional are you really? What is how does your organization work? And the contract is a very kind of easy and effective way of creating that professional image, because you have a contract. It has all the things that need to be in there. They're not unfair. They're not unfair to the client. They're not unfair to you. And you're able to just, put that out there, and they can see, well, okay, look, this person is both creative and they're capable of giving me a contract that says what we need to talk about. In terms of the content of the contract, there are a lot of common issues. Every design services contract is going to have a lot of the same basic elements, but what we try to do is we sit down with you, we get an understanding of what's important to you, what you want to focus on, the different way, people have different ways of doing business, and some people want to get paid this way, and some people, it's important that they have a certain level of control over installers and subcontractors, and some people want to have less control. So we understand how you operate, how you as a designer do your business, what your installation philosophy is, how your sketching process is, a lot of different things, and then we try to incorporate that into the contract. For us, the primary issues that we're looking at when we're trying to craft a straightforward replicable contract is, first and foremost, we want to make sure that you get paid. So the payment terms need to be clear. They need to, be reflective of what works for you in terms of your cash flow and in terms of your invoicing. It's great to get paid more frequently, but if that means that you have to invoice more frequently, then there's a balance. So we try to figure out what works best for you. The other big thing that we focus on is your intellectual property. And we talked about this before. It's great to do a job, and it's great to get paid for doing a job, but what you really want to be able to do is you want to leverage the jobs that you've done in order to get more jobs. So it's critical to make sure that you secure the rights to use the intellectual property that you've created, in social media, in books, to promote your work in a variety of different mechanisms. And again, you want to get that up front in a contract, because what you don't want to do is you don't want to finish somebody's project and then have to go back to them and say, excuse me, can I, and would you agree to this? It's never a pleasant conversation, or even if it is, it's something that's unnecessary. So that's another aspect that we like to focus on, is the intellectual property component of it. And then, there's a variety of things that are kind of more internal to the contract, a little bit more, purely legal in terms of, who's indemnifying who's responsible for what, things like that. But, we try to keep it simple, and we try to make sure that you get the fruits of your labors, both in terms of being paid and in terms of being able to promote your work.
Right, and that's really important to do, and all of that can be illustrated in the contract. So how do you typically structure those things, or what would you say are best practices for being sure you get paid?
Well, I mean, best practices for being sure you get paid really involves a couple of components, right? Make sure that you're gonna issue an invoice, right? And there's going to be a period of time for the client to object or question the invoice. If they don't object or question to it within that period of time, then they're going to be deemed to have consented to the invoice, and they need to pay you. And, the question I think that you're getting at is what happens when a client doesn't want to pay you. And, quite frankly, and this is what I was saying at the beginning about the contract only being as good as the people on either side of it. If the client doesn't want to pay you, you want to have a contract that clearly sets forth your right to get paid and the payment terms and schedules. And then there are things that you can put in it that make it a bit more onerous if the client is not paying you. For instance, if the client doesn't pay on time, there can be interest associated with the outstanding balance. There can be other things that you have the ability to do, such as withholding materials or withholding work. You're always going to want to strike some kind of balance between the reputational aspects of it and what's going on. You're also going to want to get an understanding of why the client's not paying. Some clients, there may be a client that just, is not paying and they just don't want to pay. They're just going to be difficult, whatever the case may be. That's a different situation than a client who is traveling and doesn't have access to a payment mechanism, or a client who is experiencing some kind of short-term cash problem. And so what we do is we first encourage people to have an open dialogue and get an understanding of exactly what's going on, because that's going to guide what your next steps are, or how, quite frankly, aggressive you're going to be in seeking to collect what's owed to you. Beyond that, there are a variety of different mechanisms that you can use, kind of in an escalating fashion, from, writing letters to, potentially putting liens on things, all the way up to having to litigate if you have to litigate. And then, of course, in that situation, it's going to be a matter of how much is owed and what it's going to look like. Where do you have to litigate? What's that going to cost? And to that end, we always want to make sure that clients have an attorney's fee clause in their contract, because it's one thing, if a client owes you X amount of dollars, but it's going to cost you Y amount of dollars to recover that, and you don't have the ability to recover your legal fees, it's somewhat limiting. So that's the way that we look at it.
And also, when is a good time to send your client a contract? Negotiations can be a little blurry, and it can be hard to gauge how committed our potential clients might be. What are your best practices for that?
Well, look, it's going to vary. All clients are different. All designers are different. It's going to vary from client to client. But I think the thing is, and this is another situation where there's a lot of similarity in between what you do and what I do, is that, when I'm talking to a potential client, at some point I need to send them an engagement letter, both for compliance and regulatory purposes, but also to make sure that I'm going to be compensated for my time. And there's always a question as to when you're going to send that letter out. And as a designer, there's the same question is when you're going to send the contract out. So sometimes it's going to be an easy call. You're going to have an understanding. You're going to have conversations. You're going to sketch out what you're proposing, and the client's going to say, "That's great. I'd like to move forward." Well, "I'd like to move forward" is a pretty clear indicator that it's time to send out a contract. All right. There are other similar situations where you get the sense that you've kind of given the client enough, or the potential client, enough information to work with. It they should be capable, and you can push out the contract at that point. And sometimes a less adversarial way of doing that is to say, "Look, you have my proposal. I think you have a good understanding of what my plan is and what I can do for you. I also wanted to send you my contract so you can get a better understanding of how I work, what the terms and conditions of my services are." So that's not necessarily a situation where you're saying, "Here's my contract, sign it," or we're not going to do business. It's just, a gentle reminder that, hey, there's a contract involved in this process. And here it is, take a look at it. Let me know if you have any questions. So that's kind of a second situation. Another situation, and this is always the difficult situation, is when you have a potential client who you just feel is going to keep dragging you down the path and dragging you. Can you just elaborate a little bit more about this? Can you give me another sketch about this? Can I have your thinking about one more thing? And you, as a designer who understands what's enough, start to get that feeling that, like, this is enough. And if you want to test the potential client in that situation, a good way to do it is to send out the contract and say, "Look, I think we've provided enough information. I think that you should be in a good situation here. Here's our contract. Let me know what you think." And that kind of falls into the putting your money where your mouth is category, because as a designer, as an attorney, as anybody involved in offering professional services, I mean, we want to get clients. We want to sign people up. We want to get paid, quite frankly. But there are inevitably some people who are going to take advantage of our time, and being able to kind of have a sense for when that's happening and send out the contract to try to put an outer limit on it. I find that's an effective mechanism as well. And I also find that it's effective for designers in particular, because designers really, in my experience, they want to share, right? They have ideas, they have things that they want to do, and they want the world to know about it. They want to put it out there and they want to share it. So their first instinct is to provide more information, to provide more planning or more thoughts. And what we try to do is pull that back a little, because you can't take back something that you've given to somebody, particularly if you've given it to them without a contract or without any understanding of who owns what. So, you know, we want to push out a contract there as well, and try to get our clients to say, okay, look, you know, we've given you enough information. You should be able to make a decision at this point. And that's the way of testing whether somebody is for real or not, or, you know, whether somebody, you know, and I'm not saying a lot of people do this, but some people do it, is just trying to get you to do enough work so that they can go out and just replicate it on their own without actually paying you to do the work itself.
Right. Yeah, that's great advice, especially structuring within that contract what you're willing to do. Like, for example, you are allowed 3 sketches or 3 revisions. After that, it's this much, this much, this much for each additional revision or each additional mock-up. It's so essential to be able to say no and to lay that up on the ground right off the bat, so that we're all happy and that the client understands where those parameters are. They don't always understand how much work goes into that and how much time it can be consuming. So let's circle back to
just one more thing on that point. That also kind of relates back to the contract itself. And one of the things that we have to address frequently is, you know, so when you're doing an install, you know, clearly whatever you finish and whatever you're doing for the client is the client's property, which is, you know, another reason why you want to make sure you get your intellectual property rights. But some people will want prior iterations of what you're doing. So there's always some kind of tension about, like, who owns the sketches that led up to the work that was being produced. So clearly, you know, as somebody who represents designers, but who also has been a client, you know, I understand, and I want designers to own as much of their material as possible, both, you know, for a point of reference and to use for promotional purposes. So I think, you know, Garrett, that's a good point as well about, like, well, how much am I going to give you? You know, I mean, and both pre-contract, right, you know, I think I've given you enough sketches, like, you should be able to make a decision, and post-contract, you know, I'm going to do this, you know, for this fee, and this is what you're going to get. But if you want more, if you're going to, you know, if you're going to try to micromanage me, or if you're going to have me pull things back out, you know, that's going to cost you more. There's a regular rate, and then there's kind of, you know, I'm being inconvenienced rate.
Right. That's fantastic. So contracts can essentially help designers establish ownership and claim their rights to using that work later on in self-promotion. It can help designers lay out the parameters of how they're going to get paid and how they're spending their time, and really be able to plan ahead about what their profitability is and what they're willing to do in that work, and also protect their rights as a designer should something go wrong, and they can end the relationship if they aren't getting paid moving forward. That's fantastic. And I think that's a service alone that's very much worth talking with you and consulting with you further. Let's circle back to licensing, because I am seeing a lot of questions coming in there. And I know a lot of designers here aspire to working with bigger brands, collaborating on wallpaper, pillows, chandeliers, and other home good products. So how would you negotiate, or how do you work with designers to help them negotiate a proper percentage, especially when it's unknown how popular that product might be?
Well, I mean, look, a lot of it is about expectation management, and a lot of it is about control. And that's the way that I view licensing agreements. Licensing agreements are a mechanism to be able to put your products out into the stream of commerce, but to retain a high level of control over them. And for me, that control comes through 2 primary negotiation points, right? One is, what's your territory going to be? You know, and 2 are, what are the sales channels that you can use? You know, for instance, we do licensing agreements with some people that only allow the licensors to sell through wholesale channels. Some are precluded from selling online. Some are only allowed to sell here. Some are only allowed to sell over in Europe, and you're retaining your rights in other places. So my fundamental philosophy when it comes to licensing is start small, right? You want to you want to test the market for your product. You want to test the market in a meaningful way, but you want to retain as many of your rights as possible so that you can enter into other arrangements, which also kind of goes to a fundamental issue in licensing agreements, which is, what's the level of exclusivity? You know, and you want to have, to the extent possible, a non-exclusive license, right? You want to be able to license your products to as many people as possible, without diluting your brand, or without, you know, making somebody upset that you know, that this person over here is selling it, but this person's selling it as well. And part of that is, again, managing your your counterparty's expectations. So in terms of licensing in general, I think there's a couple of different buckets. You have like, and they're be pretty flexible when, if they're coming to you and saying, hey, we want to license your product, we want to license your design, they're going to say, this is our standard licensing agreement, and this is what we're going to do, and we're not going to do anything different. What I say is that that's not true. I've worked with a lot of large retailers, a lot of large manufacturers, and inevitably they will negotiate. And the thing that designers need to keep in mind is that when somebody comes to them and says that they want to license their design, they've already made a commercial decision that it's of utility. Somebody somewhere has decided that this is something. They didn't come to you to say, I want to license your design because I want to see if it would be interesting or not. They think that they can make money off of it. If they think that they can make money off it, there is flexibility. While there may not be a lot of flexibility in dealing with a large organization in terms of their jurisdiction clause, like, if there's a dispute, you got to litigate with us in Texas, which is an issue that we just dealt with on behalf of a client. But there's going to be some flexibility in some of the other things. One of the big things that people want to know about when we talk about is what's the standard royalty rate? What can I get for it? And the reality is I'll give you two answers for that. One is that if you want to get in touch with me privately, I'll talk to you about it. But in the interest of my clients who I represent in connection with these types of matters, I am not going to telegraph what we would consider to be generally acceptable rates, because obviously what we want the best rates possible. We want our clients to be able to make as much money as possible through as many counterparties as possible, and to do it in a transparent fashion, which is to say, look, we'll do this licensing agreement with you, but we're retaining rights and we intend on licensing through these channels as well. So that's that. And I'm not trying to be coy about the royalty rate. It's just I can't negotiate against myself publicly. So.
No, I think that's absolutely a great answer, because I think that oftentimes we adhere to standards, or we adhere to the averages thinking we're doing a good job by following those. And actually we're leaving a lot of money on the table and a lot of opportunity on the table by pursuing averages and standards. And so talking with a lawyer about what the value of this might be, especially one who, like you, who's familiar with the industry and knows how things have been going in the past, can really aggregate and take advantage of and optimize what that fee should be. So that's an incredible opportunity that, again, many lawyers don't have access to, and why it's difficult as a creative to work with most lawyers. So that's a huge and tremendous asset service to our industry.
Well, one of the things that we also say on that is that one of the things that that I find most annoying in this context, and this applies to work that I do with designers and work that I do with startups and work that I do in general, is that people will come to me and they'll say, well, we think that we should do this. This is a market rate, okay? I don't believe in market rates. I believe in using market rates as indicators for what's reasonable and what's not reasonable, but everybody's different, right? Every client is different. Every designer is different. So what you're going to do, what you're going to negotiate depends on a variety of different factors. So while we may use a market rate to make sure that we're not below a market rate, we're not going to be defined by what the market is. And our clients, and what we do for our clients, is we make the market, right? We're going to decide what we're going to put it out there for. And sometimes that, means that we have to counsel our clients to be, a bit more circumspect in what they do. And the issue is again, because designers want to put their material out there, a lot of people try to jump on, it's what somebody wants to license from me. This is spectacular, and they'll give it away for whatever. Don't do that. It requires a bit of a steady hand, a bit of a poker face. But the bottom line is that if they decided that they wanted in the first place, they're probably going to do a deal with you. And 50 basis points, 75 basis points, 100 basis points, a percent, is it really going to make a difference one way or another? If they have enough confidence in what you're going to do, they'll give you what you want, because it's not going to make a difference to them.
Right. And that's just it. We often tend to make decisions, especially about our business, on an emotional level because we're so passionate about what we do. But again, we can be selling ourselves short because these companies run their companies like businesses, and they are capable of having that straight face in negotiating what their standard fees are. And we should be empowered to respond the same way. So that's why I think it's also wonderful as a designer to be able to partner with lawyers and with people who have a more level-minded about how business works, because while we can jump up and down and get excited, somebody else can say, yeah, that's awesome, but let's optimize this. What can we really get you here? And it's amazing to have somebody in your corner in that respect. So we were talking with licensing, and I see some questions coming in about patents. Tell us the difference a little bit between copyright, trademark, and patents.
So all three, copyright, trademark, and patents, the underlying premise of all of them is that people who work with their minds should be able to secure what they call the fruits of their labors, right? And so they're all a mechanism to allow people who create things to own their creations. So they range from, this is my perspective on it, they range from the simple, which is copyright, to the somewhat more complex, which is trademark, to the super complex, which is patents, right? So as a disclaimer, in order to prepare and file patents, you need to be licensed before the Patent and Trademark Office. So there are a special class of attorneys that do patents. I'm not a patent attorney. What I do in terms of patents is I work with a lot of clients who have patents in terms of carving out licensing agreements for what they've created, in terms of dealing with issues associated with, overlapping markets, or, can they license to this person and still use their invention for something else? So that's on the patent end. And, what a patent will do is it'll afford you, there's design and utility, it'll afford you ownership over what it is that you created and the ability to prevent other people from knocking you off and creating the same thing. In terms of trademark is the ability to mark your images with your logo, whether it's, Garette, or, whether it's Waterworks, or whatever your trade name is. And, that is more complicated than copyright, but less complicated than a patent. So what a trademark allows you to do is to distinguish yourself through your mark and through whatever it is you've registered with the trademark office, and people can't use the same thing in order to try to rip you off. So trademark is based off of likelihood of consumer confusion, exclusive use of certain words and certain combinations of words or certain logos and other images. And that's the trademark. The trademark is something that you do generally need a lawyer to work with, because trademarks are issued in a variety of different classifications, and they can be a little complicated in terms of, well, this is what I do, but you want to make sure you're registered in a variety of different classes and across boards. And then the trademark office is iterative, right? They will come back after you make your filing, and they'll tell you, how long you can, whether you need to disclaim something or whether you don't need to disclaim a word. And some of those things can be confusing if you're not an attorney. A copyright is just inherent, right? A copyright is the inherent ownership rights that people have when they make things. And a copyright is simple and complicated at the same time. So first of all, what people need to understand is that you definitively do not need to have a lawyer in order to copyright something, all right? If you make something and you're capable of establishing the date that you made it on, that's your copyrighted work. You own it. People can't use it. They can't infringe on you. And that just exists. The difference between having a copyright and registering a copyright is pretty huge. And I think registering a copyright, I think the cost right now is like $60. It's not a huge cost. And it's simply a matter of mailing in your material to the Copyright Office. The Copyright Office, unlike the trademark office, is not iterative. They don't review what you've sent in. It's registered. So you send it in, it gets registered, and that's the way that it is. And then you own the copyright. The difference between having a copyright, and some people, think of it as, well, if I put what I make and I put it in an envelope and I mail it to myself so that it creates a date, then, that's fine. But, in these days when everybody's operating off of the computer that has a bunch of metadata in the back, it's pretty easy to establish when you've made something. So if I own a copyright, if I've made, let's say that painting behind you, right, that's my copyrighted work, right? Now, if I've registered that copyright, here's what the big difference is going to be, is that if I now think that you're infringing my work, and I have not registered my copyright, my ability to go to court to get an injunction, my ability to go to court to get any kind of treble or consequential damages as a result of your infringement is severely limited. And most importantly, at least from my perspective, your ability to get legal fees in connection with bringing your action is non-existent. You cannot recover legal fees. And as somebody who has litigates on behalf of people, I can tell you that an enforcement action, particularly if you're dealing with somebody who has a lot of money, can be very expensive. So the thing to understand is that when you make something, you own it, and you are allowed to prevent people from using it, from infringing upon it, from using the fruits of your labor for their own benefit. But it's very difficult to enforce it unless you're able to demonstrate that you've registered your copyright. So in that vein, as far as trademarks are concerned, we work with clients to help them file trademarks. To be honest with you, we actually outsource it because there's another firm that we work with that is much quicker and much more proficient at dealing with the trademark office. So it's something that we kind of act as a conduit for, but we don't do in-house. In terms of copyright, we try to provide clients with an easy form so that every time they do something, they can put it in an envelope, send in the fee, and copyright their work, whether it's one or as a series of works, for instance, all the sketches that are related to a particular installation. So in general, that's the difference. Each one affords different periods of protection. Copyright is the longest, patent is the shortest. But trademark is renewable. So I guess it kind of depends on your perspective.
Right, that's really interesting. So how do you continue to help designers protect their intellectual property from being stolen and ideas online, even after they've taken those steps?
Well, so in my experience, most designers are pretty good at policing their designs. So there are a lot of different things that we can advise clients to do in terms of being able to continually scan a variety of different places. It starts off as basically as a Google alert, with machine learning and a lot of other things that are being offered right now. It's also very easy to identify images and have an alert set up through a variety of different databases if somebody's promoting it online, which is going to be your most likely source of infringement. So that's kind of the easier thing. In terms of the if somebody is using something in a private location, it's going to be difficult. And then the question is going to be, how much of your time do you want to spend trying to hunt down and police these kinds of activities? I don't think it's going to be super productive, particularly if it's something that is not being displayed, nobody's making money off of. I mean, your damages are, they exist, but they're going to be somewhat limited.
Interesting. Yeah, I had a friend of mine's artwork got kind of lifted and ended up in a car commercial. So it seems like it's easy for even companies, I mean, people definitely, but even companies to feel like because they found something online, they can use it. So having somebody that can help you protect those assets, he did eventually call it out and got paid for it. Probably not what he would have negotiated in a contract had they hired him, but he did get money without having to litigate, which is interesting. So it is worthwhile to police that work and to call it out when it happens. And you worked with. Sorry,
I just want to address two questions that I just saw pop up real quickly. So Wendy mentions that you can file online and you can file sequentially, which is true. You can file online, and as I pointed out before, you can file a series of things at once as long as they're related to the same subject matter. So that is true. And Doris is asking about utility patents, and yeah, a utility patent is a 20-year term. So trademark is 10, but it's renewable, so that's why it's longer in theory. So,
great.
Sorry.
So while we're talking about social media, because it is so easy to sort of reappropriate other people's work, can you tell us a little bit about what best practices are for either projecting our work online, and also I have been working with designers on Pinterest and things like that, and they've been wanting to promote their work by showing example of other types of work to show how they could interpret it, or to show why this is a bad example of perhaps a workplace and how they can produce a better example. How can people use other people's work online without necessarily infringing on copyright?
So, I mean, that's always a tricky question. You know, I mean, it depends on, so there are a lot of exclusions to infringement. And, you know, and what I mean by that is that there may be times when you're using other people's material, but you're using it in a way that's not an infringing use. You know, fair use is one of those, you know, derivative works is one that has some limited protection for the potential infringer. Commentary, you know, mostly related to a newsworthy purpose. But, you know, it can be more in the vein of, you know, and just commenting general and using it as an example. So I think in terms of the question that you're asking about the ability to use other people's work in connection with furthering your own commercial interests is always a little difficult, because one of the things that, you know, enforcement actions are sensitive to is what's the commercial aspect of what you're doing with somebody else's work. So, you know, it's one thing when you post somebody else's work and say, like, you know, this is spectacular, look at this. You know, I mean, that's probably why somebody put it up in the first place, and they probably would appreciate that. It's another thing when you say, like, you know, this is what somebody did, and you know, I can do the same thing. Like, that's pretty close to you trying to say, like, I don't own this, but I can do the same thing. You know, it's another thing when you say, like, you know, here's an example of a poorly designed this. Now, that person is probably not going to be super excited about the fact that you're using their work in that context, but I mean, the reality is that you're commenting on it. You're making a comment that this is something that is, you know, whatever, antithetical perhaps to what your design ethos is, and, you know, you would do it this way. So it's almost as a compare and contrast. What I would say in general is that, you know, regardless, like, you want to give attribution. You know, some people think, well, okay, so like maybe it's a better idea if I'm going to use somebody else's work, and I'm just, you know, not going to mention that it's somebody else's work. Well, you know, if you put it out there and you say this is somebody else's material, you know, I got this from this, or photo credit to this, and that's a big thing, is making sure people get appropriate photo credit, then it's going to be a little bit better. In general, for our clients, we try to not have them do a lot of that. But on the flip side of the equation, we try to make sure that what they do put out there is somewhat protected from that. And we do that through two primary mechanisms. One, we want to make sure that, you know, it's identifiable and copyrightable. Whether they've registered it or not, we just want to make sure that all the information is there. The other thing is watermarking, right? We want to make sure, we want to make it as difficult as possible for somebody to lift the image and use it for their own purposes without there being some attribution on it. Or if they're going to clip out the attribution, it makes it that much harder for the person to claim that they were using it in good faith, when we're able to prove through metadata and a variety of other means that they affirmatively altered the image in order to remove the attribution on it. So, look, the reality is that, you know, there's been a lot of cases recently, the Mercedes-Benz case. There's a lot of things that are kind of still evolving in the social media space, and this includes a conversation that I had recently about, like, the extent of the license that you give to the social media organizations when you post things on there, because you're giving them a license to continue to use your material that you posted in basically any way that they want, whether it's for their promotional purposes or something else. And issues can come up in that regard, both in connection with your own work, but for instance, and this is something that we address in, you know, this takes us back to the design contract realm, is that you want to make sure that you have the ability to use the collateral material that you develop for your client in a public forum, with the understanding that that may make it subject to further licenses that you don't have control over, right? So, I mean, it's kind of like when somebody goes to your website, you want to have a disclaimer on your website that says, look, I'm not responsible for third-party links. Like, you want to have the third-party links on your site. You want to be able to align yourself with other designers, with other companies, with, you know, with other people that, you know, are proximate to your space, but you don't want to be responsible for what happens when somebody clicks on that link. I mean, you know, if that link has been corrupted, or, you know, if somebody ends up getting, you know, a virus, and not talking about the virus, but so it's kind of the same philosophy there about, you know, making sure today that the things that I'm going to do next week, next month, next year have already been thought about, they're already accounted for, and I don't have to worry about what the consequences are going to be, because I've already agreed between you and me that this is the way that it's going to work out, and this is what I have the right to do.
Fantastic. Thank you for that. And before we open the floor to questions, because we have about 15 minutes left, but I do want to talk about, because we are in the world we're in now, and I wanted to talk about liabilities for COVID. So say you have a contractor going to a person for an installation and COVID happens, how do you protect yourself as a designer from that liability?
Step number one is wear a mask. Make sure that everybody around you wears a mask. And please wear a mask, everyone. So it's a bit of a loaded question, right? Because, although it seems like this has been going on for an eternity, we're kind of still in the early stages of all this. And for me as an attorney, what does that mean? Early stages means that there has not been a lot of litigation on this. There has not, there's been very little litigation on this, and who's responsible for what, for when. So what we do is we kind of just default to ordinary principles of understanding where the blame shifts from one person to another, or who's responsible or who's not responsible. And so really what we try to do is we try to number one, and I think first and foremost, is we try to make sure that our clients are compliant with state and local requirements. And I'll use New York as an example. In New York, any business that's in New York that's going to be open in any respect for business, and although some designers don't think of themselves this way, you're a business, right? You may just be, Bob Dobalina, the designer, but you're Bob Dobalina, business of design. So you need to have the New York Forward Safety Plan template, and what that is you can get it online through the New York Department of Health. You fill it out, and it says that, to the extent that I have anybody other than me coming and doing anything, these are the protocols that I'm putting in place to make sure that they're safe, that I'm safe, that other people are safe as a result of interacting with them. So and then there's an affirmation that goes along with that. So step number one is compliance. Compliance also means understanding what the rules are in the various jurisdictions that you might move in and out of. For instance, right now, although I live most of the time in Manhattan, I'm in Massachusetts. Massachusetts last weekend passed a new regulation that if you come into Massachusetts from any state other than, I think it's about 7 states that are quote unquote safe states right now, if you haven't had a negative test in 72 hours, you have to quarantine for 14 days, right? So there are some exceptions to that. There are some exceptions to every rule, but you need to understand what the rule is, because if you're going to be going into that state for 2 days to do an install, let's say, and you don't adhere to the regulations, but if God forbid you get sick and somebody at the site gets sick, although it would be virtually impossible for them to make any kind of causal connection between you and them unless they had not gone out at all and you're the only person that they'd seen in the last 2 or 3 weeks, the issue that you're going to have is that you're going to be negligent per se, right? And what I mean by that is that you were aware of some, or you should have been aware of some kind of rule or regulation. You didn't adhere to the rule or regulation. There was some kind of bad consequence. And as a result, there's a problem. We don't necessarily know that it's your fault, but it's going to be your responsibility to try to get yourself out of this. So that's on the regulatory front. On the other front, we just try to put everybody into 2 buckets, right? There's buckets of people that we control and buckets of people that we don't control. People that are outside of our control, we just try to make sure that our clients are acting responsibly and making sure that they're trying to have these people act responsibly. The perfect example is when you're doing a job, there are, let's say the installer is somebody that you're bringing into the job, but the contractor is somebody that the client hired, right? We view the contractor as the client's responsibility. We view the installer as your responsibility. And so what we do is we try to make it as basic as possible. For most of our clients, we have a certification that they get signed by employees if they're going to go to the office, employees before they're going to go to an offsite, installers or other people that they're bringing onto a job site. And it just says the basic facts, right? I don't think I have COVID right now because I don't have any symptoms and I don't have a fever. To the best of my knowledge, I haven't been around anybody that has COVID in the last couple of weeks. I have not tested positive myself for COVID in the last couple of weeks. And, and that's it. And we get that signed either formally as a signature, or for most of our clients, it's informally just as a reply email that says, read and understood, which we think is sufficient for this. So at the end of the day, the way that we deal with COVID, other than trying to be personally responsible and trying to do the right thing, is just by trying to do things that are more likely than not to be informational in terms of who we're dealing with, and making sure to the extent that we can that we're not bringing employees or other people that are quote unquote under our control into contact with other people.
Got you. So being transparent and signaling responsibility to your clients and building trust is really the most essential way to guard against that at the moment.
Look, I think being transparent in all your dealings with your clients your business is your reputation. And, so it's important for them to understand what you're doing and why you're doing it. And I also think in that vein that, to be transparent with your client, but to give them the space to make their own decisions. It's one thing to say at 8 o'clock in the morning, oh, by the way, I'm coming to your job site and I don't really know what I've been doing for the last 2 weeks. It's another thing to say 2 weeks in advance, look, when I'm going to be at your job site on, August 19th or whatever the date is, I just want to let you know, this is what I'm going to have done before that. Because you may know already that you're going to be traveling. You may know that you're going to be doing different things. So yeah, you want to try to be transparent and let your clients make the decisions, and make sure that the people that you have under your control are, to the best of their knowledge, certifying that they don't think that they have a problem currently or haven't been around somebody with a problem.
Great, definitely new territory. So I want to open up the floor to questions. I do see some in the chat. Jess, are you there?
I'm back. Hello. I have a couple of quick ones that I've just been reviewing, but I want to let you know, Gavin, that people are really happy with all of the value and information you've been providing. Lots of positive feedback and thank yous being put into the chat. One quick question from Keith was, what is the normal royalty rate for products, like in terms of a percentage?
Yeah, so I think I've addressed that. So, the normal royalty rate for our clients is the highest rate that we could possibly get. And if Keith wants to call me, and I suspect that Keith has my number, I can talk to Keith specifically about what I think, what I think would be applicable for his particular situation. And that being said, I would just like to say, hi, Keith, thanks for being here today.
I know you touched on patents. There's a specific question here from Doris. What do you do with patents? I was required to get a utility patent to present my Euro-style bath cabinetry to a huge company. Do you do this? Can you elaborate?
So thanks, Doris. I think that question probably came before I discussed it in detail. So no, we don't file patents. So if you are still in the phase where you need to get a utility patent, you can get in touch with me. I can help to shepherd you towards somebody that's able to help you in connection with that. If you have a utility patent and you're looking to structure a deal for licensing your patent and your designs, that's something that we would be able to help you with. But patent attorneys are a whole different breed of people. They're generally engineers by background, and then they've gone to law school and they operate on a level that, quite frankly, I don't want to operate on. And you want to talk about minutia. So.
Well, this next question is about patents again, so don't hate me. Just I think more general question, is a utility patent usually valid for about 20 years? Does that sound about right?
Yeah, again, the patent people are better, but my recollection is that utility patents are 20 years, design patents are 10 years. And yeah,
great.
Pretty straightforward.
What liability insurance for a new design business that does not have a brick and mortar location, what liability insurance is necessary to protect myself and my LLC?
So, the first thing that I'm going to say is, it is consistent with my philosophy in general, which is step number one, read the instructions, or, in this particular case, you want to go to the person with the best knowledge. So in general, I'm going to refer you to an insurance broker. I'm going to say, you need to explain to the insurance broker exactly what you're doing, and they're going to be able to tell you what kind of coverage is necessary. That being said, and in the interest of not overbuying insurance coverage, there's a variety of different factors that would go into that. Do you have employees? What kind of work, in specific are you doing? Is it more residential? Is it more commercial? But you want to have, the biggest thing that I want to make sure that clients have that a lot of them don't have is you want to have errors and omission insurance. And basically that's insurance for being negligent, because it's pretty easy to procure insurance for, intentional acts. but it's a bit more difficult to, sorry, it's the other way around. It's pretty easy to get negligence insurance, but it's difficult to get intentionality insurance. And hopefully you're not going to go out and commit an intentional act, but there is a higher likelihood that some negligence might occur at some point during your business cycle. And if that's the case, you want to have E&O for that. In general, we also advise people to get an umbrella policy. Usually what that is, it's tied to some other policy that they have. The most frequent is your automobile policy, or if you have a condo or a co-op, it could be your homeowner's policy or your renter's policy. And what it is an overarching amount that will cover you for a wide spectrum of occurrences. And so we like umbrella policies. That's it. But insurance brokers are the way to go. They know the most, and they're pretty good.
Do you have any other pressing questions right now, Garrett?
No, but I did want to reiterate about the summer membership sale, and also Seth is offering free consultations to IFDA members. So if you do have some interesting things, or you're growing your business in certain directions and you would like to talk with a lawyer, Seth is your guy.
Yeah, I mean, I don't know if you guys have put up my contact information, but yeah, we're available. We're happy to consult with people from the IFDA and just try to give you some advice as to what the best practices are, what the best way of going about doing this or that or the other thing is, and try to help give you a little bit of guidance in what is admittedly a very uncertain time.
Yeah, definitely. I think a lot of this was really super useful information for me, my friend Garrett, for our member base at large. My favorite takeaway was you talked about sending an engagement letter. I think it's a really nice reminder to all of us to really engage with clients early on about setting a contract and really making things clear and to make our lives easier long term. So thank you so much for sharing all of this information with us. It's obviously a super important topic, and we really appreciate you taking the time.
I appreciate being here. I appreciate being able to spend the time with you, and look forward to talking more in the future.
Great.
Thank you so much, Seth.